This is an appeal in the matter of ABC and Huntercombe and others.
Yes, Mr. Fetter.
May it please your lordships, my name is Fetter. I appear on behalf of the appellant with Mr. Edwards. The first respondent, Huntercombe number 12, limited involuntary liquidation, is not represented today, but I understand has contacted the court in writing. The second respondent, represented by known friend Mr. McPherson, is the other active participant in this appeal. The third and fourth respondents, represented by Miss Chan and Miss Hayworth, respectively, taking neutral positions.
Yes.
My lords, this is an appeal by the claimant from an order which is at page 41 in the core bundle, made on the 17th of November last year. I should say that you have additional core bundles. They are identical, but we noticed that we in our copies had glitches in the pagination. And so those have clear, continuous pagination.
A bit late,
I do apologise.
isn't it? I mean, we've had to mark them up by reference to tab numbers, which they have had, but getting a paginated bundle on the morning is not very helpful.
I apologise.
We've already marked up the documents.
I think we should assume we're actually physically going to be using the old version, but by all means say, and that's page 87.
Thank you. The order is made by His Honour Judge Bird, sitting as a High Court judge in the Manchester District Registry, deciding preliminary issues. You should have, and I should check, you should have, apart from the two bundles, core and supplementary, and the authorities bundle, a supplemental authorities bundle from Mr. McPherson. May I check that that is with you? Thank you. Subject to your leading, I will, if I may, open with some preliminaries. I will begin with underlying facts and find my way through to the issues before you on this appeal, before your lordships on this appeal. The appellant was detained at the age of 16 under the Mental Health Act for over 4 months at the Huntercombe Hospital, Maidenhead, in 2018 and 2019. And her case, in a nutshell, is that while there, she was repeatedly physically, mentally and verbally abused by hospital staff, and that her treatment amounted to gross violations of basic care standards and her convention rights, including Articles 3, 5 and 8. She was on her case physically restrained alone over 200 times during her 4-month detention. And in short, rather than doing her good, the treatment to which she was subjected caused her serious and long-term injury.
Could I just interrupt, say, I'm sure everybody in court is aware of it, but the identity of the claimant is protected by an anonymity order which remains in force.
I'm grateful, Your Lordship. There are over 50 similar claims behind this one, regrettably, brought by other former patients at the Huntercombe Hospital, Maidenhead, and other hospitals in the Huntercombe group, which have been issued and served and are due for case management in the High Court in the autumn. This appeal is important to those claims also.
Is there a date for the case management conference?
Not yet. It's anticipated that it'll land in September, my lord.
Right, and the hearing in October or September?
September's
vacation, I just wondered.
Yes, it's Master Cook who's managing.
Right.
And I believe that September is available, but it may turn out to be October.
Yes, all right. Well, once we've risen, if the parties could keep us informed so that if there is a date, because obviously there will be the question of the judgments. So
yes.
If we could be kept informed as to when that hearing gets fixed, that would be good.
Certainly. Thank you. The first defendant, now in liquidation, owned and operated the hospital at which the appellant suffered these experiences on her case. It transferred its business to the second defendant, to the second respondent, in March of 2021, and it's uncontroversial that the Transfer of Undertakings Protection of Employment Regulations, the TUPE regulations 2006, applied to that transfer. The first defendant has public liability insurance, but we're told it's subject to a very large per claim deductible of £250,000. That's something that Mr. Macpherson refers to in his skeleton argument. Such that the appellant and other victims in her position would not, if successful against the first defendant, recover a large proportion of the damages to which they would otherwise be entitled. And it's the appellant's case that by virtue of the TUPE transfer of the hospital business, the first defendant's vicarious liability at common law for the torts of its employees at the time of transfer and its imputed liability for their human rights breaches passed to the second respondent, which is a trading and solvent entity. We understand its insurance position to be no better than the first defendant's, but it is a trading and solvent entity. And those employees included not only the consultant psychiatrist responsible for the appellant's treatment, but of course all staff within the hospital responsible for other aspects of her care, nurses, matrons, etc. The transfer will not have applied to everyone, but it will have applied to a proportion. It did certainly apply to the two psychiatrists who were the responsible clinicians under the Mental Health Act for her treatment, responsible for her case, in the words of the Act.
That's the third and fourth respondents.
The third and fourth respondents, yes. Obviously, were adequate public liability insurance available, it wouldn't have been necessary to join either. A preliminary issue trial was ordered of the question whether vicarious and imputed liability transferred under the TUPE regulations, under Regulation 4.2, and if so, whether public liability insurance cover transferred with it. And the trial took place in March last year. And the preliminary issue can be seen from the wording of the order, my lords, at page 41 of the core bundle. The preliminary issues are set out at page 42, second page of the order.
So that's tab 4.
The appeal is from the responses of the judge, the learned judge, to the questions at issue 1, where a negative response was given to the question of whether vicarious liability transferred. So far as issue 2 is concerned, the judge found that had he found the other way, he'd have found that the insurance transferred with the liability, and there's no appeal from that finding. And it's common ground between the parties that imputed and vicarious liability go together. So the focus of this appeal and my submissions will be, and Mr. Macpherson's, will be on the vicarious liability question. The judgment is just behind the order, starting at page 44. If I may turn now to the grounds of appeal, starting at page 15, they begin in earnest at page 16. your lordships will have seen that they're subdivided, and I will address the individual elements. But in essence, we say that the judge erred in, firstly, his construction of Regulation 4.2 of the TUPE regulations, simply in failing to hold that vicarious liability is a liability in connection with the contract of employment for the purposes of that provision. And secondly, that he failed to interpret that regulation in a manner consistent with the Acquired Rights Directive which it implements. And had he done so, we say, he would have held that transfer of vicarious liability was consistent with it. Before addressing the substance of those grounds, may I take your lordships through the relevant provisions? The regulations appear at the start of the authorities bundle.
Yes.
Beginning at page 3, if I could ask you to turn to page 7, please. Regulation 3 addresses what a relevant transfer is, a transfer to which the regulations apply. Regulation 3.1a, if I may draw your lordship's attention to that, is that such a transfer undertaking business or part of an undertaking or business, takes place where there's a transfer of an economic entity which retains its identity. An economic entity is further defined at Regulation 3.2. An organised grouping of resources which has the objective of pursuing an economic activity, whether or not that activity is central or ancillary. Regulation 4, which is at the heart of this appeal, is at page 11. And Regulation 4.1 provides that where a relevant transfer takes place, so a transfer of the nature addressed by Regulation 3, unless the employee objects, that's the objection under paragraph 7 referred to at subparagraph 1, the transfer does not terminate the contract of employment of that person, but rather such contract, end of the paragraph, shall have effect after the transfer as if originally made between the person so employed and the transferee. That is what, by agreement, took place here, so far as the transferred employees are concerned. And then 4.2, on the completion of a relevant transfer, all the transferors, this is 2a, all the transferors' rights, powers, duties and liabilities under or in connection with any such contract shall be transferred by virtue of this regulation to the transferee. And that's the key provision which we say the judge interpreted incorrectly. While Regulation 4 is open, may I also direct your lordships to paragraph 6 on page 12, where there are reservations. Well, there's a reservation at 6 in respect of criminal liability, which is expressly said not to transfer. And at Regulation 10, on page 25, there is a further reservation in respect of certain provisions relating to occupational pensions. Before leaving the regulations, I should mention briefly Regulation 11 onwards, which deals with notification of employee liability information. There is a notification process that goes with a transfer under the regulations. Obviously, the relevant parties doing the deal can arrange whatever information sharing they choose. This is the obligatory notification. And those provisions, the notification and the remedy at Regulation 12, have been held to be provisions that transfer. That's the Alamo case to which I will come. The Alamo case, I should say. Coming to the end of the preliminaries, may I ask your lordships to turn to the Acquired Rights Directive, please, which is at page 52 of the authorities bundle. It is the recitals that we see at page 52. That which is important to the issues before your lordships is, or most important, is 3. It's necessary to provide for the protection of employees in the event of a change of employer, in particular to ensure that their rights are safeguarded. And we say that the learned judge took too narrow approach to that. And finally, Article 3.1 of the directive at page 54. This is the provision behind Regulation 4.2. Article 3.1. The transfer's rights and obligations arising from a contract of employment or from an employment relationship existing on the date of a transfer shall by reason of such transfer be transferred. Of note is the following paragraph that Member States may provide for joint and several liability as between transferor and transferee. That has not happened in the regulations. The UK Parliament declined to do that.
So what's the effect of that? It could have been jointly and severally liable. The transfer and the transferee could be jointly and severally liable. But Parliament didn't do that, so the transferee, if it's transferred, the transferee is solely liable.
Yes, for that which transfers, yes.
If it was transferred.
Yes.
Yeah.
With those preliminaries in place, I come to the first ground of appeal, and ground 1A, which is that the judge failed to give the ordinary and natural meaning to Regulation 4.2a, and particularly the phrase in connection with the contract of employment. And for reference, this is paragraphs 43 onwards of the appellant's skeleton argument.
Yes.
Yes, it may assist your lordships to have regulation 4 open by way of reference. It was page 11 of the authorities bundle. It appears in several places, of course, in the bundle. Standing back, any personal injury lawyer worth his salt knows when they encounter an employment contract in the facts of their case that 2 liabilities on the employer's part flow from that fact, the fact that there is such a contract, such a relationship in place. The first is a liability for health and safety at work, a liability for harm that the employee might suffer in the course of his duties, his or her duties at work, due to dangers at work. And the second is liability for the employee if he or she harms others while at work or acting in the course of employment. Vicarious liability. They're different liabilities, but they are both connected with, flowing from, the fact that the contract of employment is there. And there's more to say, but that is this ground and this submission in its essence. That vicarious liability, obviously, logically, is a liability in connection with a contract of employment. Particularly so when one considers the ingredients of vicarious liability. There must not only be a contract of employment, an employment relationship, but the liability only attaches if the relevant harm is done in the course of the employee's employment, for which there is a close connection test. The wrongdoing must be so closely connected with the acts the employee was authorised to do, employed to do, that the wrongdoing may fairly and properly be regarded as done in the ordinary course of employment. It's a trite proposition, I appreciate. You see it in multiple Supreme Court authorities that have come through in recent years on vicarious liability. It features in one of them in the authorities bundle, the case of Madrovsky, at paragraph 25. I won't take your lordships to it, but your lordships note it's page 366 of the authorities bundle.
Just remind me of the tab in the authorities bundle.
12.
Thank you very much.
Both are tortious liabilities, both the liability for harm suffered by the employee at work and harm caused by the employee at work. There is authority from this court, the key authority for the purpose of this appeal, the case of Martin and Bernardone, that liability of an employer for in tort, for breach of its duty to take care for the safety of employees at work, passes under TUPE. And we say the same applies to vicarious liability. It is connected with the contract of employment, and it is a strain on the natural meaning of those words in Regulation 42A to see it otherwise. Now, the learned judge respectfully neglected that starting point.
But it's not necessarily the right starting point when you're dealing with regulations which are implemented in order to give effect to a directive. I mean, there's lots of authority in the bundle about the approach which would be adopted in those circumstances, including the principles set out in this court in the Vodafone case, and I'm sure you're very familiar with. So why should the natural and ordinary meaning of the words be the correct starting point, rather than the question of looking for the purpose of the directive, which should guide one's interpretation of what other language has been used?
Well, my Lord, I don't suggest that the two are siloed completely. But in order to know, first of all, whether the provision is consistent with the directive, which is the first step in that process, one must ascertain its meaning.
Absolutely. I mean, that's what we're all searching for. But the question is how you set about that task. And if you were construing an ordinary Act of Parliament without any EU law connections, you would naturally start with the language, and that might well be where you end up as well. On the other hand, the authorities seem to be very clear that where you're looking at domestic legislation introduced in order to implement a directive, the task is rather different, because the whole purpose, at any rate at the time when these provisions were brought in, was to ensure compliance with the directive, which is a part of the overriding legal order of community law, to which the whole domestic statute book is subject.
My Lord, yes. And so, and the authorities to which I think your Lordship is referring are very clear that where one interprets a provision on its natural and ordinary meaning, and that natural and ordinary meaning undermines or is inconsistent with the directive that the provision seeks to implement, then one must interpret, read down accordingly, and can do considerable violence indeed
absolutely.
to the wording.
And maybe this is just a quibble about the order in which one approaches it, but I'm just slightly taking issue with your emphasis on the clear and natural meaning as a matter of ordinary English, as the starting point, rather than part of a more holistic exercise, which mustn't lose sight of the fact that it's a directive which is being implemented.
No, that's absolutely right, my Lord. Another way to put it might be this, that the learned judge did not start by asking whether the meaning of the provision was consistent with the directive.
I mean, plainly, that's got to be considered at some stage.
Yes.
As before you reach a conclusion, and that's really all I'm putting to you. I don't think you're disagreeing.
No, I don't think I am, my Lord. And it's really those two elements that we say he failed to do. He failed to find the ordinary natural meaning and see whether that was consistent with the directive. If it was, then there's no need to do violence to the interpretation or change the interpretation to which one has come on the basis of the directive. Forgive me, my Lords, I'm just looking to see whether, yes, I think it might assist, my Lords, if I go to the case of Swift and Robertson, to which the learned judge went very early on in his approach to this wording.
Yes.
So at paragraphs 9 and 51 of the judgment, the learned judge said that Swift was the starting point. It's at page 402 in the authorities bundle. At tab 14. My Lords, if I could ask you to go to paragraph 20 at page 408. There we see the section in Lord Kerr's judgment on the correct approach to interpretation of the regulations in that case. And the citation of the case of Schulter. Where the European Court of Justice says what, I submit at least, corresponds with the last submission I made, that the key is to find an outcome consistent with the objective pursued by the directive. We see that at letter H. The same point appears in the following paragraph, 21, the reference to Vodafone 2 and Sir Andrew Morritt's dictum from paragraph 7 of that case on page 409 of the authorities bundle. Four or five lines down. In summary, the obligation on the English courts to construe domestic legislation consistently with community law obligations is both broad and far-reaching. And it's at that point that we get into the points that were quoted by the learned judge and appear also in learned friend Mr. Macpherson's skeleton argument, that there's a broad and far-reaching power which doesn't require a trigger ambiguity, for example, to bring domestic legislation into conformity, into consistency with the underlying EU law. But this isn't a situation where the interpretation, the natural interpretation, as we say, was inconsistent with the directive. I'll, of course, develop that, but that is our position. And the judge is cutting straight to that process, which was inapt, led to him taking an excessively narrow approach to the construction of the regulation. I should mention that it's not suggested, or hasn't been suggested to this point, on behalf of the second respondent, that our interpretation is inconsistent with the directive. The suggestion is that it doesn't further the directive's purpose, which is not the same thing. It doesn't take things further. And the learned judge, and this is ground 2A from recollection, didn't consider that either, whether the interpretation contended for by the second respondent, which he upheld, was consistent, more consistent, less consistent with the directive than the one put forward by the appellant. I will submit that ours is the more consistent, fits better with the purpose of the directive. Finishing the point about consistency, I should take you to, your lordships, to the case of Martin. Not for the first time, well, it is for the first time, not for the last time, forgive me. Page 243, tab 8. This was the decision I mentioned earlier in which the Court of Appeal, this court held that the liability of an employer for health and safety at work passes. It goes somewhat further than that as well, to which I will come. But the relevant provision for the purposes of the submission I'm making at this point is paragraph 16 in the judgment of Lord Justice Peter Gibson at page 251. That the regulations, it wasn't in dispute in that case, the 1981 regulations, which are the predecessor to the 2006 regulations before your lordships, must be given a purposive construction having regard to and so far as possible consistently with the underlying directive. That will be important when I come to address ground 2. If I may, I will revert to ground 1 for now. I think it will, I hope it will be a more organised way for me to approach the issues in the appeal.
You don't want anything else from Martin at this stage?
At this stage, no. The point I make is simply that the approach it took, which I will rely on in my submissions to come, that was lying behind the approach of the court. The purpose of the directive and interpreting the regulations consistently with it.
Yes. That much is not in dispute.
No, indeed, my lord. The judge proceeded, having not carried out the exercise of identifying the natural ordinary meaning and asking whether it was consistent with the directive and its purpose, then held that liability had to be, that is to say, liability that transferred, had to be direct in order to transfer. It had to be directly connected with the contract of employment. That's paragraphs 56. 52A of the judgment. So the holding was the decided cases show that the connection between the liability of a transferor and the contract must be direct, in the sense of being a liability the transferor has to an employee if the liability is to transfer. So having failed to start with the meaning, the natural meaning, and ask whether it was consistent with the directive, the judge then arrived at a very narrow interpretation that those words in connection with the contract of employment were limited to a direct connection in the sense of being a liability owed by the transferor employer to its employee. There was only one decided case, as it happens, on the point, and that had gone the other way. That was the case of Douane, His Honour Judge Robinson in Sheffield County Court, which had held that vicarious liability did transfer. The other decided cases didn't deal with vicarious liability. And they certainly didn't, in my submission, confine the wording in the way held by the judge, or legitimise reading in the word direct into Regulation 42A. That is the sort of thing that one does when one finds inconsistency, and none had been found with the directive, and none had been found. And in truth, and this is where I return to Martin, the decided cases emphasise the breadth of that terminology. If your Lordship still have Martin open, may I ask you to turn to page 243 in the bundle, so they... Forgive me, that's the heading. It's paragraph 17 to which I wish to take you on page 251 over the page 252. In the course of Lord Justice Peter Gibson's reasoning, he cites a memorandum on the acquired rights of workers prepared by the European Commission in 1997 and cites it, quotes it, bottom of page 251 over to 252. Your Lordships will see that the section on 252 from the end of the second line states the transferee is bound by all the transferor's obligations resulting from an employment contract or an employment relationship, including those which arose before the date of transfer. In the court's view, that's the ECJ at the time, the directive refers unreservedly to the transferor's rights and obligations arising from a contract of employment or from an employment relationship existing on the date of transfer.
What does that tell us that wasn't
It's
obvious in the wording of the directive?
It's emphasising the breadth, my lord. The directive refers unreservedly to the transferor's rights and obligations arising from a contract of employment. So, for example, there's no suggestion that it's confined to the parties to that contract. And indeed,
these are not words that we're interested in, are they? I mean, when you said there were plenty of authority for the breadth of the terminology, I assumed you meant liability in connection with, because that's the terminology in the regulation. This is dealing with arising from, resulting from, which on one view is narrower. So I think actually in connection with is your better point.
it is.
Rather than an EU memorandum about different wording.
My lord, yes, I accept that. It's the first stop on a route through Lord Justice Peter Gibson's judgment.
Okay.
And Lord Justice Peter Gibson does refer interchangeably in some places to the wording of the directive and the wording of the regulation. Paragraph 35 we come to the regulations. Rather than reading it out, my lords, may I invite you to read paragraph 35 in full.
Yes.
There the point is made indeed by Lord Justice Peter Gibson that the phrase in connection with is broader than the phrasing in the directive. And indeed that the reservation in respect of criminal liability indicates that even that would or might transfer were the reservation not there. And similar comments are made at paragraphs 36, where Lord Justice Peter Gibson refers to the far-reaching effect of the 1981 regulations, and at 38, yes, 6 lines down. The language of Regulation 5.2 is wide enough, without any express reference to tortious rights and liabilities, for the reasons already given. This is in relation to the finding that liability and negligence was transferred. Negligence in relation to the employee's health and safety at work was transferred.
And this is still good law, isn't it? If your client had been an employee bringing a personal injury claim originally against the transferor, and the employee was transferred, undoubtedly the claim would lie against the transferee, right?
Yes. Yes. And so the question is whether that breadth in connection with the contract of employment extends to vicarious liability. We say yes, it does. And indeed, it obviously does. The breadth is can further be illustrated by the way the Court of Appeal treated liability under the Occupiers Liability Act in this case, which follows at paragraph 39. Now, liability under the 1957 Act is, of course, imposed on occupiers and is statutory in nature. It doesn't arise from the contract in the ordinary sense of that wording. That is the wording of the directive. It doesn't arise from the employment relationship. One can certainly use the phrase. It flows from, in certain circumstances, but it's a statutory liability imposed, as it were, from above, and here it was held to transfer in the same way as the duty in respect of health and safety at work. Mrs. Bernardone had been injured on hospital premises. She was a catering assistant in the course of her employment with her then employer, Pall Mall Services. That activity had been taken over by the trust, and liability as occupier under the statute transferred from one employer to the other. And that was because it was in the course of her employment that she'd gone into the relevant place, the relevant storeroom, and sustained injury.
So it arose in connection with her contract of employment?
Yes. So it was
39.
Factually in connection with her contract of employment. It went with the employment relationship, to put it another way. Just as vicarious liability goes with the employment relationship. Vicarious liability for what the employee does wrong goes with the employment relationship. It is like occupiers' liability, as it were, imposed from above. It's a common law doctrine, but it goes with the employment relationship, as on the facts the occupiers' liability did here. And then, less direct still, at paragraphs 45 onwards, this court held that the liability of the employer's liability insurer to indemnify the transferor in respect of the accidents at work suffered by the employee transferred to the transferee, to the new employer. Now, that was, in our submission, clearly not direct. it was parasitic, one could say, but it was indirect so far as the employment relationship was concerned.
Is there a liability to indemnify? In an ordinary claim against an employer stroke occupier for personal injury by an employee. The cause of action being that another employee, the tortfeasor, did something negligent to cause injury. The claim is usually brought against the employer because the employee may have no money and may not personally be insured, but is there a legal liability on the employer to indemnify the employee?
In respect of the employee's personal liability,
Yeah.
for what he's done at work. It would depend on the contract terms, but not on the face of it.
Mr. McPherson, I think, is going to rely on Lister and Romford Ice to say,
Yes.
actually, in law, not in the real world, but in law, the liability to indemnify is the other way around.
Yes. Yes. Well, there's a problem with that, my lord, which is there can be absolutely no doubt that liability under the contract of employment passes from transferor to transferee. So the liability of the employee to indemnify the employer, which is contractual, must pass to the transferee. And it's absurd, in my submission, for the indemnity to pass, but the liability not.
We need to unpick this a bit. I mean, I was a personal injury lawyer once. Lister and Romford Ice has
Yes.
always been notorious as being contrary to what most people think should happen in real life. But anyway, the
Yes.
3-2 majority of the House of Lords held that the duty of the employee, who may usually is uninsured, is to indemnify the employer who is insured, and thus the insurance company, against all liability. And if he's bankrupted, too bad. But there is no you say the that you say that there's a liability to indemnify, liability on the employer to indemnify the employee, and I'm not sure what it is.
My lord, no. Sorry, you referred to Lister, and I immediately thought of the liability on the employee under the contract to indemnify the employer. So in a situation where there is vicarious liability by the employer, of the employer, for whatever the employee has done wrong, Lister says that whilst the employer must pay out the damages, the employer has a right of indemnity in respect of those damages from its employee, because the employee owes it a duty to take reasonable care and skill in the course of his or her duties. And that is a contractual duty, a contractual indemnity, a term which passes on transfer without a doubt. It's part of the employment contract. So what I'm saying is it cannot be relied upon in favour of the respondent's position that the indemnity somehow renders absurd or undermines the appellant's interpretation of Regulation 428. It actually works the other way. The transferee gets the indemnity, there's no doubt about it, because it's under the contract.
If the liability passes. Because this is all based on your premise that vicarious liability is transferred.
My lord, no, forgive me. This is a term of the contract which passes regardless. So the the obligation of the employee to use reasonable care and skill in the course of his or her duties, which gives rise to the right to indemnity, passes to the new employer, to the transferee. And that's on the strict wording of Regulation 42A. It's a liability under the contract. So that must pass. And if vicarious liability doesn't pass, then we're left with the transferor being vicariously liable, but no longer having the indemnity that the House of Lords in Lister says the employer has.
Yes. You premised that on the basis that the vicarious liability passed under Regulation 4. Which
My
is
Lord,
your case.
that's my case,
but if that's wrong, and it doesn't pass, which is the respondent's case, then the point doesn't arise.
if it's wrong that vicarious, if your lordships find against me that vicarious liability doesn't pass,
Yeah.
it will nevertheless remain the case that the terms written into the contract and implied into the contract do pass. That is already the law, my lord. So
Okay.
the indemnity passes. The right to indemnity held to exist by Lister, in Lister, passes. So the situation as if my learned friend Mr. Macpherson is right about the law, then the law is that the transferee holds the indemnity following the transfer, even though the transferor is vicariously liable.
Why?
Well, if my learned friend is right that vicarious liability doesn't pass, then whatever the employee, the recalcitrant or negligent employee did before transfer, rendering the transferor vicariously liable, that vicarious liability to the victim remains that of the transferor. That's the respondent's position.
Yes.
Now, ordinarily, the law is that the employee has an obligation to indemnify under the employment contract following Lister, the employer. So the employer can take advantage of a contractual indemnity against the employee, the negligent employee for whom it is vicariously liable. That will not apply post-transfer if the law is, as my learned friend says it is, because the indemnity, the contract, has passed to the transferee. The transferor doesn't have that right, doesn't have a contract anymore with the employee, the transferred employee. So, cutting to it, I was building to it, perhaps a bit too slowly, my lords.
Maybe a bit too quickly.
So the position is that, and I'll come round back to it if, well, that'll be my plan unless your lordship stop me, is that in law, it is absurd for vicarious liability not to transfer. One of the reasons for that, perhaps the best reason for that in strict pure law, is that the indemnity transfers. Indeed, my learned friend has included a recent authority confirming that the indemnity still exists. The contractual indemnity still is very much a feature of our law today. So, as a matter of law, for that indemnity to make any sense, vicarious liability must transfer. Then you have the liability and the indemnity together, held by the transferee. Thank you, my lord. I'm conscious that it may help if I finish this point by reference to the specific wording of the regulation,
Yes.
42A. It was page 11 of the authorities bundle. Your lordships may have it elsewhere. Just going back to the wording, which I find tends to refuse to stick in my mind. 2A, what on the completion of relevant transfer, all the transferor's rights, powers, duties and liabilities under or in connection with any such contract shall be transferred. So putting that wording to the submission I've just made, the indemnity is under the contract. There's no question about it, it transfers. We say vicarious liability is in connection with the contract and should also transfer. And the fact that the indemnity does transfer renders things absurd otherwise, as a matter of law. My lords, I was in Martin, forgive me, I've taken you away from it in the authorities bundle. At paragraph 45 onwards. And the most straightforward, forgive me, it's a long chunk, but if I could invite your lordships to read paragraphs 45 to 49, your lordships may prefer to do that. I don't know whether your lordships prefer to do that now or in the break, but...
No, let's do it now.
Thank you.
Yes.
Your lordships will have seen that Mr. Edelman, King's Counsel, sought to urge the court against holding that liability under the insurance contract, the employer's liability insurance policy, liabilities and rights under that policy, could be held to be in connection with the contract of employment. And the court firmly held that they were. That's the effect of paragraph 48. And the conclusion, the important point is that the right arises from and is in connection with the contract of employment. because the liability insured under the contract is such a liability. The point I make simply, I'm not drawing a direct analogy with vicarious liability. The point I make simply is that there's emphasis exemplified in the Martin case of the breadth of in connection with the contract of employment. It extends even to rights and liabilities under the insurance policy taken out by the employer in respect of the damages that it might need to pay out to its employees for accidents at work. There is no basis for confining it to direct liabilities from the transferor to the transferee. Martin already goes beyond that, and the judge was wrong to confine it in that way. Before moving on from the width of the terminology, I should deal, in anticipation to some extent, with an authority that Milan Friend has put in his bundle, Barclays Bank and HMRC. This is the first case in the Respondents Supplemental Authorities bundle, which addresses this point in a different context. That is to say, the breadth of in connection with, the wording in connection with.
I think at this stage I have to confess that I'm not sure I have the supplementary authorities bundle. I have got the supplementary bundle. It's not the same thing.
I believe Milan Friend has a spare.
I do, madam.
That's very kind of you, thank you. Yes, Barclays and HMRC.
Yes, my lord, I don't yet know quite what Milan Friend will make of this case. It's not a TUPE case. It comes from his side of the courtroom. It's a case about the wording in connection with in the context of tax liability. The question was whether a payment made by Barclays Bank to compensate retired workers for the withdrawal of a scheme they were running to help them with their tax returns, whether that payment was liable to tax. And the critical question was whether it was given in connection with past service. And what was held at first instance by the Special Commissioner was, in order to be in connection with past service, there had to be effectively a direct connection. It had to be a remuneration, a reward for past service. So a similar sort of ruling from that made by the judge in this case. And a chain of Supreme Court judges to be led to the opposite conclusion. The case was argued by Ingrid similar QC as she then was. The Special Commissioner was overturned by Mr. Justice Richards as he then was. And it was Lady Justice Arden who gave the, as she then was, who gave the leading judgment of this court. And the paragraph which Milan Friend has emphasised is paragraph 18. It's at page 7 in the Supplemental Authorities bundle. Where something is said about the expression in connection with, the case of Coventry Waste and Russell is cited. Pausing for a moment to give your lordships the opportunity just to read that citation.
yes.
Having to do with might well be a good ordinary natural meaning. I think what it may be relied upon for this paragraph is the second part of that citation, that the phrase is a Protean one which tends to draw its meaning from the words which surround it. There's another part to that in this judgment of Lady Justice Arden as she was. Though I should say in passing that that citation relates to dealing with, and we see the last words in it, a problem created by ambiguity. This is not a case of formal or syntactical ambiguity. But in any event, it's paragraph 30 that is the, as it were, the denouement of the reasoning in this section of the judgment. And there the answer is given by Lady Arden to a submission that sought to confine the meaning of the phrase in connection with past service by reference to the fact that this legislation related to retirement schemes in some way. And at paragraph 30, Lady Arden states that one must examine not just the provision but the context, first sentence, but the context, fifth line, will not of itself justify the court in limiting the provision to that context and thus reducing its apparent scope, unless there's some indication in the legislation that this is what Parliament intended. Rather, at the last sentence, the limitations prescribed by Parliament are the limitations that should apply. And the sentence before that, Parliament has used a broad expression, namely the expression in connection with. Having cast the net widely, Parliament has drawn it in particularly by imposing a limit that there should be a connection with service. And that is what we have here in my submission, in connection with the contract of employment. It's a broad expression and must be taken to have been deliberately used as such.
Well, if one were interpreting a domestic statute and accepting, as I think I do, speaking for myself, that in connection with the natural and ordinary meaning of the phrase in connection with is very broad. But does that necessarily apply here?
That, of course, is the question at the heart of appeal, my lord. And in a nutshell, we say, and we've said from the outset, it's not a concession, we never said anything else. We've always said, not every connection suffices. And we entirely accept that that is right. But we say that vicarious liability is an obvious candidate to fall within that phrase. It's consistent with the directive. The anomaly to which I've referred earlier in law arises if it doesn't transfer. It's the other big duty that an employer owes where there's an employment contract, the other big liability that goes with an employment contract, along with liability for health and safety at work. And it's dependent on, it's not just, the contract isn't just incidental, the contract of employment. Vicarious liability depends on the contract of employment being there and the employee doing something closely connected to his duties under it, to his status as employee. the culmination of the judge's reasoning, I've addressed how in my submission the judge went off course with respect in his addressing of this question of interpretation. The culmination was that the land judge ended up giving a different meaning to the phrase in connection with, depending on whether he was dealing with rights or liabilities. And we see that at paragraph 52 of the judgment. It's at page 59, forgive me, in the one. Tab 5. The learned judge held, in my judgment, the decided cases show, this is in his resolution section, conclusion section. Firstly, the connection between the liability of transfer and the contract must be direct, in the sense of being a liability the transfer has to an employee if the liability is to transfer. I've addressed why that is wrong in my submission. And if the transferor has a vested or contingent right against a third party, which arises purely as a result of such a liability, that right will also transfer. So in 52A, the liability that passes must be direct, otherwise it doesn't pass. But in B, a right doesn't have to be direct.
Well, it's a right that arises as a result of that liability.
Yes. So it's indirect.
It's not a right generally. I'd understood 52B to be giving effect or summarising those passages you took us to in Bernardoni.
Yes.
Effectively.
Yes. And the point goes with the one I've made earlier, that in my submission, the judge has ended up reaching a conclusion that is internally inconsistent, because inevitably the insurance contract is not a direct matter between employer and employee. It's indirectly connected with the contract of employment.
Speaking for myself, I'm not sure I find direct and therefore indirect very helpful.
No.
It's a question of whether it arises in connection with the contract. And you can see why in Bernardoni, having found that the employer had a liability as employer to the employee, that was therefore a liability that was transferred. You could see it follows on from that any insurance in connection with that liability would also be in connection with the contract.
My lord, yes. Yes.
So you can see that, but I certainly speak for myself, I follow that submission. Mr. Vetto, are we leaving in connection with?
Essentially, yes.
All right, well, I don't think it's going to make any difference at all, but if you and Mr. McPherson could indulge me and perhaps ask your juniors to look for it. There was a case about in connection with in this court called Ashville against Elmer, which is reported in 1989. When you look at the representations who was attending on that court, you will realise why I know about the case. It was my first ever reported case. It simply says that in connection with are words of the widest import, which I don't think is going to be controversial. But I'd be grateful if you'd look at it just to make sure that there isn't anything else in there. And as I say, as my judicial career comes to an end, it's rather nice to have a case that was my first reported case on the same point.
Thank you, my lord.
But I don't think I think you will all find it makes no difference at all.
I'm grateful. My lords, I think you still have the judgment open, and the next point, which is ground 1D as it happens, I've almost got to the end of ground 1, is that the learned judge seemed to also confine liabilities that passed to those which were, in his words, fundamental parts of the employer-employee relationship. That's 54. And we say that simply doesn't work. If that was what the judge intended to do, that's how we read that paragraph, then it is also wrong. It is excessively narrow, and obviously so in the light of the Martin case. Neither Wilson and Clyde Coal nor Baker and British Gas stands for that proposition. There are fundamental obligations of the employer to the employee that go with the employment contract. That's what Wilson's says. They are enforced in Baker, but there was no basis in law in our submission for that finding, if indeed that was the import of what the judge was doing there at paragraph 54. The words are broad, and they need to be given the breadth that they have, subject, of course, to the other criteria for interpretation, but those criteria, leaving the directive aside, are subsidiary. And with the directive, consistency is the keystone. And it's to the directive that I now come. Now, the learned judge, as I've said, didn't address consistency with the directive at all. He plunged straight into the factors, the methodology that one would follow if dealing with an inconsistent legislative provision. And as I've submitted, he didn't address, therefore, whether either interpretation put before him was consistent or inconsistent with the directive. But we say our interpretation is right, and it's consistent with the directive. On its ordinary and natural meaning, it's right, and it's consistent with the directive as well. And indeed, it is more consistent, if that's the right way to put it. It better accords with the directive and its purposes than the interpretation put forward by the second respondent.
So just for my note, we're moving to ground two.
We are, my lord, yes. Forgive me for not making that clear. Thank you.
Yeah.
The relevant objective of the directive is that to which I took your lordships earlier at recital number 3, the protection of employees, in particular to ensure that their rights are safeguarded. So the objective is the protection of employees, in particular or especially to see that their rights are safeguarded. Now, where an employee has committed a tort in the course of his or her employment, the doctrine of vicarious liability means that the employer is the primary target of ensuing litigation. That is the real-world position. And if the employer is solvent and or insured, then the claimant will often, one might even say usually, not sue the employee as well, naming the employer as sole defendant. That provides some comfort and restricts the exposure that an employee would otherwise have to litigation. If vicarious liability doesn't transfer, bearing in mind that public liability insurance is not compulsory like employers' liability insurance, it rests with the transferor, which is likely to be the more financially fragile entity, might not be adequately insured, and so the employee will be exposed, as here. In a sense, this case is the perfect storm. The insurance is inadequate, the employer is bankrupt, the transferor is bankrupt. That is the vicariously liable party on the respondent's position. If vicarious liability transfers, it transfers to an economic entity which is the more likely to be solvent, minimising the employee's potential exposure. So the position that accords better with protection of employees is that vicarious liability transfers. It doesn't just fit with the law and the wording, the natural wording of the regulation. It also fits with the relevant purpose of the directive. And this is something, that tendency, probability that the transferor will be the more fragile economically of the two parties to the transfer, is something that is mentioned in Martin at paragraph 34, and in the case of Litster, rather than Lister, Litster, by Lord Oliver. And I think I probably ought to take your lordships to both those references.
Yes.
So Martin is paragraph 34. Tab 8, paragraph 34. And it's from the third line, the economic entity carrying on the undertaking after the transfer will be the transferee. And in general, the employees are more likely to be protected if the rights and obligations to be transferred are more rather than less comprehensive. The obvious reason for that being that the transferee is equipped to compensate. In Litster, it's put even more explicitly. Litster is at tab 6, page 170. And the relevant reference is 562H within in the internal pagination. So page 186 of the authorities bundle. Between G and H, in fact. It may, I think, be assumed that those who drafted both the directive and the regulations were sufficiently acquainted with the realities of life to appreciate that a frequent, indeed possibly the most frequent occasion upon which a business or part of a business is transferred is when the original employer is insolvent, so that an employee whose employment is terminated on the transfer will have no effective remedy for unfair dismissal unless it's capable of being exerted against the transferee. Well, the same applies to who is the target of a claim arising from a tort committed in the course of that employment. The argument against that, on behalf of the second respondent, we're returning to a previous submission. The argument against that is, well, that's not really protection of employees, because of the clawback, because of the indemnity that the employer has against the employee. But I've already addressed why that doesn't help the respondent by way of objection, because it's inconsistent in law. The indemnity transfers. So in fact, both positions assist the appellant. Both the legal reality, which is that there is an indemnity, and the indemnity and the liability ought to go together. So both should transfer, otherwise it's absurd. And the practical reality, even in Lister, it was the insurer, not the employer, going for the former employee or the employee, the tortfeasor. The practical reality, which is that, generally speaking, employers don't take advantage of that clawback. And so the employee is, in reality, better protected if the liability, vicarious liability, is with a solvent employer.
Can you, just for my benefit, can you articulate in a sentence what you say the right is of an employee in relation to vicarious liability? It is the right to...
I don't say there is a right, my lord. I may be slapped on the wrist by those next to him behind me for that, but it doesn't look like it. There isn't a right. It is, but this is not protection of employees' rights in the legal sense. This is protection of employees. And that is the way the recital to the directive expresses its purpose. Protection of employees, comma, in particular, of employees' rights.
So you don't say there is a right, you say it is covered by the general word protection.
Yes. Yes.
So it should say protection from personal liability.
Yes.
Protection from
That's the...
protection in practice, so
yes.
perhaps not in law, from personal liability.
Yes. But it's the very point that is adverted to in the Martin case at paragraph 34. But there it's a different liability that's being dealt with.
Well, there it's the liability to the employer. Sorry, to the employee.
Yes, exactly. So employees are better protected.
This is a liability effectively to a third party.
Yes. Yes. It's a liability to a third party, but it is for something for which the employee is the tortfeasor.
Yes.
So, and has committed the tort in the course of their employment, we say in connection
So
with the contract.
the employee in a vicarious liability situation, the employee is in law primarily liable.
Yes.
The employer's vicarious liability is secondary as a matter of law.
Yes.
It's a secondary liability. But your argument is that in the practical sense, there is protection for an employee if the employer is vicariously liable.
Yes. If the employer is vicariously liable and worth suing. And
in that connection, do you rely on what Judge Robinson said in Duane about it being to the benefit of the employee?
Yes. Yes, it corresponds with what Honourable Judge Robinson said in that case. I do go further, though. I haven't yet, but I will.
We're obviously waiting with pen.
Well, I will do so immediately. There's a further purpose for vicarious liability, in which we see within not just the Madrowski judgment, which is in the authorities bundle, but also in the extracts from Charlesworth and Percy, which Land Friend is included within the bundle. If I could start with those. The purpose, I should say, is that vicarious liability serves the amelioration of standards for employees. And the point is simply that, again arising out of this practical reality, that the transferor will generally be the weaker economic entity, often insolvent as here. That beneficial effect will only be felt in the transferred economic entity under the management of the new employer. It's page 55 of the authorities bundle. So this is an extract from Charlesworth and Percy on negligence, included by my learned friend, dealing with policy behind vicarious liability. At 709 at the bottom of page 55, admittedly by reference to Basley and Curry, Supreme Court of Canada, but it appears again in Madrowski. We see the authors state that the second major policy consideration behind vicarious liability is deterrence of future harm. Employers were often in a position to reduce accidents and intentional wrongs by efficient organisation and supervision. Failure to take such measures might not suffice to establish a case of tortious negligence directly against the employer. For beyond the narrow band of employer conduct that attracted direct liability lay a vast area where imaginative and efficient administration could reduce the risk that the employer had introduced into the community. Holding the employer vicariously liable for the wrongs of its employees might encourage the employer to take such steps and hence to reduce the risk of further harm. Well, not if the employer is defunct and indeed no longer employing the relevant employee, but only if vicarious liability transfers to the new employer, deemed to be the employer ab initio, following the transfer. The relevant passage in Madrowski is paragraph 9. It's page 362 of the authorities bundle. There, Lord Nichols addresses the fact that there are a variety of policy factors going into the doctrine of vicarious liability and deals with this one in the last few lines, about 7 lines up from the bottom of that paragraph. It means also that the financial loss arising from the wrongs can be spread more widely by liability and higher prices. In addition, and importantly, imposing strict liability on employers encourages them to maintain standards of good practice by their employees. For these reasons, employers are held liable for wrongs committed by their employees in the course of their employment.
Sorry, where are you reading from?
Oh, sorry, my lord. It's internal pagination 1202, letter E. Bottom of paragraph 9.
Oh, right. Yeah. Thank you.
So in my submission, the natural and ordinary interpretation that vicarious liability is a liability in connection with the contract of employment accords with and is consistent with the directive and its purpose, its relevant purpose. It's well to say something as well about Parliament's purpose in achieving that policy aim. The effect of regulations 3 and 4 of TUPE is that effectively the employment relationship is transferred, as it were, lock, stock and barrel from the transferor to the transferee. There are very few exceptions. And the new employer is deemed to have been the employer ab initio. That's Parliament's purpose. That's Parliament's mechanism, as it were, for achieving the directive's purpose. It's anomalous, illogical, for vicarious liability not to go with it. The employer before was vicariously liable for what its employees did wrong and that caused harm in the course of their employment. The relationship has now moved, and everything in connection with that employment contract has moved. Parliament thereby ensuring, it's quite a blunt instrument, thereby ensuring that the policy aims of the directive are fulfilled. But that is its purpose. And it's illogical, anomalous to that purpose for vicarious liability to be left behind. Just as the previous employer was vicariously liable because employer, so should the transferee be. And that fits with the way Parliament has gone about fulfilling the purpose of the directive.
If that, assuming that's right, then is it not surprising that other than a case involving one footballer being injured by another, there are no cases in which it was found that vicarious liability was transferred?
It was the point I was about to come to, my lord. No, it's not. It's, in my submission, it's not. Martin and Bernardone post-dated the 1981 regulations by 20 years. So even that internal liability, tortious liability, that question didn't arise for 20 years after the original TUPE regulations. We're dealing with a highly specific set of circumstances which is not often encountered. It requires that a tort is committed in the course of an employee's employment giving rise to a claim. That's already a limited cohort. Giving rise to a claim that is pursued, limited again. And in the context of that claim, the employee is or has been subsequently transferred under TUPE. As opposed to all the other things that might have happened. Coming to the end of their employment, changing jobs, maintaining the same job, being dismissed, whatever it may be. And the claim has been brought, but not resolved by the time of transfer. And in practice, those are the essentials. In practice, the insurance position needs to be in some way defective. Because it's common ground that the public liability insurance would pass. But in any event, if an insurer is picking up the bill, then the precise name on the claim form may be a mere formality. Where there's an insurance problem, as here, then there's a question over both the exposure, potential exposure of the employee who is the tortfeasor, and on the victim side, finding the solvent defendant. So only then does the issue arise, and then the choice essentially, in, as it were, policy terms, or perhaps one should say the stark reality of the choice, is that either liability lands on the transferee, which is likely to be trading solvent, maybe insured, fully insured, or on the tortfeasor employee or employees being sued personally, leaving the third-party victim potentially having no remedy. But it's not surprising that this is rare. The team which I lead, and more importantly our clients, find themselves in that particular perfect storm. so far as, and I'm moving on to deal with some of the points made by my learned friend. So far as what is said to be the absurd or anomalous consequences of this interpretation, the first point to say is that it's right. If it's right, then the fact that there is complexity associated with its practical outworking is not a reason to say that it's wrong. But there is complexity anyway, whichever way this goes. Because that is what TUPE does. Following Martin and Bernardone, if, for example, there's a fire at a car showroom or a concert or a music festival, then if vicarious liability doesn't pass, but employer's liability does, then there's a different defendant depending on whether you are a visitor or an employee on those premises. There just are complexities created by the operation of TUPE here. There will be complexities or anomalies, as it were, either way. And care must be taken in my submission not to interpret legislation by reference to the circumstances in this particular case. It's something that the authors of Bennion counsel specifically against, if I may take you to the relevant section at page 63. I should say that you will have seen citations from Bennion in the Skeleton Arguments. That was the previous edition. A new edition came out in June this year. So the sections in the authorities bundle are from that edition.
It's an enormous chunk of Bennion, so I couldn't find what was being relied on, but you're going to tell us.
I will, my lord, yes. Well, at least some of it.
Just to remind me, it's useful to put in to include in the tab the title page of the relevant work that's been copied.
Yes, indeed.
Pick up points like that.
Thank you, my lord. Page 63 at the bottom, in the section entitled Core Principles. But the legislative attention may be undermined more subtly in a case by a party suggesting to the court the legislator cannot have intended the legislative provision in question to have a particular result in the circumstances that arise in that case. The true position is that the legislator does not legislate for individual cases, but sets down general rules that govern all cases to which the rules apply. The question for the court is not whether the legislator intended to produce a particular result in a particular case, but whether and if so, how the legislative provision applies to the case before it. And a second caveat within the pages of Bennion, if I may, at page 107 in the bundle. Towards the bottom of the page, under the heading Anomalies Both Ways, it may happen that each of the opposing constructions produces an anomalous consequence. This will lessen the case for a strained construction. It may nonetheless be necessary to weigh the anomalies incident to each construction against each other. So we say that the natural and ordinary meaning and the practical and legal considerations to which I've referred your lordships all militate in favour of the interpretation that the appellant puts before you. There are complexities both ways. What my learned friend refers to as patchwork. There will be patchwork in practice, there already is. But in my submission, anomalies is too strong a word, in fact. They are complexities. They're complexities that the courts are able to deal with. Apportionment, evidence. These are matters that the courts are used to. And it's important to bear in mind as well that there are also matters, consequences, that the two contracting parties, transferor and transferee, are able to address as between themselves in whatever bargain they strike on the transfer. They're not reasons to go behind what in our submission is the right interpretation. Before leaving Bennion, I should draw your attention directly to the citation from Pearson, the case of Pearson over the page at 108, where Lord Justice Buckley said, "Arguments by reference to anomalies in the construction of a statute of this kind do not seem to me to afford any very valuable assistance. The ingenuity of counsel can almost always produce possible anomalies in either direction, and that has been the case in the present matter. And indeed now in this one I have given you an example."
And in practically every case that's argued in this court, the ingenuity of counsel throws up arguments that construction X is absurd or construction Y is absurd. Yes. We have to do our best.
Yes, indeed. And I say that these practical outworkings points, one can find examples, hypothetical examples, but they are no good reason to depart from the sound interpretation which in our submission we put before this court. Dealing with such an example put forward by my learned friend, and this is at paragraph 23 of his skeleton argument, that of a commercial agent.
Sorry, give me the paragraph reference again.
Yes, it's paragraph 23 of learned friend's skeleton argument. A sort of floodgates example, that an employer has an employee who acts as its commercial agent. Are all the contracts that that employee negotiates connected with the contract of employment such that they transfer on our interpretation and all liability for those contracts, whether well or badly negotiated? And the answer is simply no, and obviously no, because they aren't sufficiently connected with the employment contract. The relevant contracts are those made with the commercial partners. The transfer, for liability to pass, the liability has to be in connection with the contract of employment. These are liabilities in connection with the contracts made by the agent with the commercial trading partners. Those are separate contracts. They clearly don't transfer. They're not connected with the contract of employment. Contrast vicarious liability, which depends on the relationship of employer and employee and requires the employee to be committing harm in the course of his or her employment. Then a further example at paragraph 50. Where it goes over the page. Take the case of a large oil multinational company which employs a maintenance team to service an oil well. And the maintenance team commits an error.
Sorry, where's this?
Sorry, my lord, it's paragraph 50 of my learned friend's skeleton argument. But the example begins over the page, top of page 160 of the bundle. just in from the top, take the case of. Well, it's just about conceivable, but it involves a large multinational oil company, in reality, having no public liability insurance. If the vicarious liability transfers, then so does the public liability insurance that the large multinational oil company will almost certainly have. But of course, it is possible that the standard trend from economically fragile to economically sound in the transfer will not always be the case. Of course, that's right. But it is generally the case, as recognised in the appellate authorities. We have cases within this cohort, not this specific case, of course. One case is before your lordships, but the 50 plus that lie behind. There are cases where claimants were treated either side of the transfer line, and so they straddle the transfer. Inevitably, there is a patchwork there. As I say, the complexities are unavoidable, especially in multi-party litigation, and indeed historical litigation such as this. So in our submission, none of these floodgates or alarmist points should deter the court from giving the legislation its natural meaning, which serves Parliament's intention in securing continuity of employment and its corollaries, and in using wide phrasing, and is consistent in our submission with the purpose of the directive, indeed serving its purpose, protecting employees both in that vicarious liability is more likely to rest with a solvent entity, and that ongoing entity will have the reforming obligation or impetus that vicarious liability brings. My lords, I think I have, not quite in the organised way I had originally sought, covered the grounds of appeal and their sub-grounds.
Very clear. We haven't left any speaking part to Mr. Edwards.
He has a just-in-case speaking part. But that is right, my lord, I'm afraid, yes.
Thank you very much. Yes, Mr. Smith, first.
So, your lordships, I'll start, if I may, with the proper approach to construing legislation that implements a European directive. Because it is our position that the judge was right to say that that's the starting point, and that there isn't any gateway or any threshold before the court should apply the principles in Swift and Robinson. Our position is that the principles in Swift are of general application. They apply whenever there is an issue of construction and you have legislation which is intended to implement the European directive. The principles are, I would characterise them as pervasive throughout the construction process. They are not in a silo, I think was a phrase that was used. They're not to be accessed only if a certain test is passed. They are of broad effect. And they do, as has already been remarked, give your lordships much greater interpretive freedom than might have been the case in relation to purely domestic legislation. And so I will, if I may, take you back to Swift, which I'm conscious you've looked at before. And it's the authorities bundle starting at page 403, tab 14. And I do think it is worth just introducing what this case is about. It was a case about consumer protection rather than employee protection in the context of a contract that was made at the consumer's home. And European regulations give consumers a right of cancellation in those circumstances pursuant to a council directive. And what the Supreme Court found in Swift is that if you applied a literal interpretation to the regulations, that would negate the purpose of them. The purpose was to protect consumers, to give them this right of cancellation. And the court expressly found that if you read those regulations literally, there was no such protection. And in those circumstances, the court thought it appropriate to apply a purposive interpretation and override the literal words of the regulation in order to give the consumer this right to cancel. And it's at page 408 where Lord Kerr sets out the applicable principles. And in my submission, this section is absolutely key to unlocking the meaning of the words that we're concerned with here. So paragraph 20, the National Court must interpret domestic legislation so far as possible in the light of the wording and purpose of the directive which it seeks to implement. This is now well settled. As that reference to the Schulte case, when hearing a case between individuals, the National Court is required, when applying the provisions of domestic law adopted for the purpose of transposing obligations laid down by a directive, to consider the whole body of rules of national law and to interpret them so far as possible in the light of the wording and purpose of the directive, in order to achieve an outcome consistent with the objective pursued by the directive. So that is the overarching principle. And then by reference to the Vodafone case, various particular features of this approach are set out. And they are startlingly empowering, if I can put it that way. They entitle the court to act interpretively in ways that go beyond perhaps a conventional approach. So the principles are listed starting on page 409 at letter B. It is not constrained by conventional rules of construction. It does not require ambiguity in the legislative language. It is not an exercise in semantics or linguistics. And that came through in particular in the Swift case, where the literal words were overridden. It permits departure from the strict and literal application of the words which the legislature has elected to use. E, it permits the implication of words necessary to comply with community law obligations. And F, the precise form of the words to be implied does not matter. And then below that, an internal paragraph 38, the point made by counsel, which was accepted, was the only constraints on the broad and far-reaching nature of the interpretive obligation are that the meaning should go with the grain of the legislation and be compatible with the underlying thrust of the legislation being construed. So, my lords, I do say for those reasons that there is no initial threshold which needs to be passed. That appeared to be the appellant's position in their skeleton, but I think with some gentle probing, Mr. Fetto has accepted that. The judge was correct to say the starting point when looking at regulations such as these is the approach set out in Swift. And I rely in particular on the principle that that approach does not require any initial ambiguity. Now, it's the respondent's case that the words in connection with are in fact ambiguous. And their ambiguity there, in my submission, which I'll go on to develop, is that that ambiguity would justify a purposive approach, even under conventional principles of construction. But in any event, Swift held expressly we don't need that ambiguity in order to adopt the broad and purposive approach. So what is the purpose of these regulations? It's been explored in various of the authorities that are before your Lordship. In Bernardone, Lord Justice Peter Gibson described it as to safeguard the rights of employees on a change of employer by a transfer of an undertaking. And that's paragraph 34 of his judgment in Bernardone. To safeguard the rights of employees when a transfer happens. And that encapsulation of the purpose is also, was also the one identified by Lord Slynn in the Wilson and St Helens case, which again in my submission is of importance, safeguarding employee rights. So if I could take you please to that Wilson case, where we see Lord Slynn identify the purpose of regulations. It is tab 7, starting at page 203. And the section I would take you to starts at page 234 of the authorities bundle.
Leave out the bits about what I submitted.
Indeed, Your Worship, I just saw your name at the top of that page. But at the very bottom of page 234, Lord Slynn says this: in my opinion, the overriding emphasis in the Court of Justice's judgment is that the existing rights of employees are to be safeguarded if there is a transfer. And I pause there to note that, of course, Mr. Fetto, when pressed by the bench, does not identify an employee right, the protection of which is secured by his construction. Though we're told that is the overriding purpose of the regulations. And then Ulston goes on to say this: that means no more and no less than that the employee can look to the transferee to perform those obligations which the employee could have enforced against the transferor. No more and no less than the obligations which the employee could have enforced. Not anyone else. Employee obligations owed to employees. Or, to look at another way, employee rights. That is, we are told, the overriding purpose of the regulations. The purpose is certainly not, in my submission, to ensure that non-employees can enforce liabilities against the transferee. Now, if the construction of the regulation drives to the conclusion that that is what was intended, I'm not suggesting that this encapsulation of the purpose of the regulations is a trump card. But it is striking that although Regulation 4 is written in very broad terms, and I do accept that, the purpose of the regulations focuses on the obligations owed to the employee. And Lord Slynn does use a limiting phrase, no more and no less. It doesn't go beyond that. But those rights must be preserved, protected in full. And there should be no derogation from those rights. So in those circumstances, as you appreciate, Your Lordship, it's not controversial between us that employers' liabilities to an employee will transfer, as found in the Bernardone case. But we do say that the thrust, the underlying grain of the regulations, I suppose, is not directed at obligations owed to non-employees. I would also ask you to note, while we're looking at Wilson that this characterization of the purpose of the regulations is entirely consistent with what was held in Bernardone about the insurance position. Because the transfer of those insurance rights does serve to safeguard employee rights and their ability to enforce those rights. It is squarely within the purpose identified by Lord Slynn. It gives employees access to an insurance fund to meet any liability that is owed to them. And of course, if those rights to that insurance fund didn't transfer, then in the event of transferee insolvency, their employee rights would have been eroded. And that would be contrary to the purpose of the regulations. So that, in my submission, is the purpose, the grain, the overriding thrust of the regulations that should be borne in mind at all stages of the process of construction. There is one other purpose of the directive that the ECJ has held should be taken into account, which perhaps can be seen as a matter of common sense, but in my submission is extremely important. And that is the balance between the interests of the employees on the one hand and the interests of the transferee on the other. The purpose of the regulations is not to take every step possible to benefit employees to the detriment of transferees. The purpose of the regulations is to arise at a fair balance between the interests of the two. And to make that submission good, please could I direct you to the ICC Facility Services against Gobert's case that is in my supplementary bundle authority, so the red bundle. So this is tab 2, starting at page 12, and I direct you please to page 17. And it is paragraphs. Apologies, it's not page 17, that's my mistake. Page 39.
No, you don't mean that.
No, put it on. My references have got.
Stick with page. Well, page 17 has got a sideline, and
Yes,
paragraph 25 looks as though it might be relevant.
Yes, I was right first time. So paragraph 25, it recites what we're familiar with now, the overriding purpose of the regulations, intended to safeguard the rights of employees in the event of a change of employer. And the purpose of that directive is to ensure as far as possible that the contracted employment or employment relationship continues unchanged with the transferee. But then at paragraph 26, the European Court of Justice held as follows. In addition, it must be stated that although in accordance with the objective of that directive, the interests of the employees concerned by the transfer must be protected, those of the transferee who must be in a position to make the adjustments and changes necessary to carry on his business cannot be disregarded. There's a reference there to a case called Warehoff. And the court went on, Directive 2001/23, so the Acquired Rights Directive, does not aim solely to safeguard the interests of employees in the event of transfer of an undertaking, but seeks to ensure a fair balance between the interests of those employees on the one hand and those of the transferee on the other. And we will see that, we go on, we'll see that in my submission when we look at the scheme of the regulations themselves. Yes, the protection of employee rights is paramount. But that is not the only thing that the regulations seek to do. They seek to ensure a fair balance between protecting those rights of the employees and the interests of the transferee the new employer on the other. And your lordships, it's at this point that I would turn to the regulations themselves and ask you to consider them not just Regulation 4, but to consider them as a coherent whole, or to understand the scheme that is set out in those regulations and what they're trying to achieve. So we're back in the main authorities bundle, and the regulations, as you know, start at page 3. So we've looked at Regulation 4. That preserves the employee's employment contract. The transferee is the new employer. Regulation 5, I'd ask you to note, relates to collective agreements entered into with trades union. And the effect of Regulation 5 is that the transfer will preserve existing collective agreements by the former employer with trades union insofar as they apply to a transferring employee. So again, squarely on point, these are employee rights that are being protected by the regulations. Similarly, Regulation 6 deals with trade union recognition. The provision protects employee rights by ensuring that if you have a trade union that's recognised before the transfer, it is also recognised after the transfer. At least where the transferred undertaking maintains a distinct identity. That's the qualification on that. But again, my point is it is focused squarely on employee rights as we recognise them. And Regulation 7 is important. It protects transferred employees against being dismissed because of the transfer. Again, the precise terms perhaps don't matter so much as the subject matter. It is aimed at protecting employee rights. But then the regulations do something quite interesting. At Regulation 11, there is a special provision which seeks to ensure that the transferee, so that's my client for these purposes, is given as much information as possible in relation to liabilities owed to employees. So we see that at page 26, Regulation 11, notification of employee liability information. And what this regulation seeks to do is to require the transferor to provide the transferee with detailed information about liabilities owed to employees. We see there the transferor must provide, and I'm reading from 11.2c, information about any disciplinary or grievance proceedings from employees, information about any court or tribunal claim from employees, either ones that have been issued already or which the transferor reasonably believes may be issued. The transferor is also required to provide information about any collective agreement negotiated with the union. That's letter E. And this requirement has teeth thanks to Regulation 12. If the transferor fails to comply, and Regulation 12 gives the transferee a remedy against the transferor and the right to damages. Now, you might, well, at first blush think, what on earth has this got to do with Regulation 4? But my point is that this is a sensible scheme to ensure that the transfer of liabilities to the liabilities owed to employees is as smooth and as seamless as possible. And I would submit it's clearly aimed at that second purpose of the directive that we looked at in the ECJ case of ISS facility. A fair balance between the interests of the employees and the transferee. These regulations are not intended to protect employee rights, or perhaps it will make the claim smoother, and so indirectly perhaps it may assist employees as well. They are aimed at creating a fair balance between imposing these liabilities on the transferee and employee rights. And they're intended, in summary, I would submit, to try and avoid any nasty surprises for the transferee insofar as the transferor reasonably can avoid that by giving them the appropriate information. Now, Your Lordships, I'd ask you to note there is no equivalent provision requiring the transferor to give any notice of any potential tortious liabilities owed to non-employees, to third parties.
Let me just look again at the information section which you showed us about claims by employees. That's 11
Yes,
2D. Yes, I see.
11.2d, information of any court or tribunal case, claim or action brought by an employee against the transferor within the previous 2 years, or that the transferor has reasonable grounds to believe that an employee may bring arising out of his or her employment. So that it is limited, of course, to liabilities owed to employees. Why would the draftsman not consider that the transferee would be helped by information about other claims, if it was intended that those claims, liability for those claims, would transfer? And this provision is of a piece, in my submission, with the entire scheme of the regulations. They are laser-like focused on protecting the rights of employees, protecting the rights, for example, of employees to sue their employer, and, insofar as is reasonable, giving the transferee as much assistance to ensure a smooth and seamless handover. Because the ruled case as set out in these regulations is that there's no obligation whatsoever for a transferor to give information about liabilities to third parties in tort. Because, in my submission, the draftsman did not envisage that liabilities in tort to third parties as opposed to employees would transfer.
Oh, would that be a convenient moment to break off?
Indeed, yes.
O'clock.
All rise if able.